Senator Kennedy to kick us off.
Thank you, Madam Chair. Judge Dudik, did I say that name right?
That's correct, Senator.
All right, what's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required any time that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required any time the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Hey everyone, welcome back to the channel. If you're new here, I'm American Interest, your independent political analyst breaking down the latest from Capitol Hill without the noise. No spin, no tribalism, just the facts and some grounded perspective. Today we're talking about a Senate Judiciary Committee hearing that's making rounds online. Senator John Kennedy of Louisiana put several judicial nominees under the microscope with a series of constitutional questions. The responses range from cautious to, frankly, concerning. Let's walk through what happened, what it means, and what we should take away from this, not just in terms of the nominees themselves, but the state of judicial vetting, the role of senators in confirmation, and whether these kind of moments are performance or genuine oversight.
The Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
They would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy Clause.
Do you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they.
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
but
Senator.
That's not what you just said. You think the Supremacy Clause applies? The Supremacy Clause applies.
Well,
you want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can. Judge Pratt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize. I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say this group, we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
tell
could
me first if a state can do that.
Yes, a state can, for example, require a driving age which discriminates on the basis of age. To say, for example,
when can a state legislature not do that?
When it's seeking to do so under a basis that is protected under the state or federal constitution.
Okay, good. Judge, tell me about the privileges and immunities clause.
The Privileges and Immunities Clause, there's a privileges and immunities and a privileges or immunities clause. There's one of each. One of them relates.
Privileges and is what I'm asking you about.
I believe you're referring to what came through in one of the Reconstruction amendments and discussing the fact that that the privileges and immunities of citizenship would be extended under those.
First, what article is it in?
I believe it's in the 13th Amendment.
No, 4th. Article 4. What does it do?
Senator, you have pinpointed a question that in my 9 years as a judge, in my decade of private practice before this, my 2 years as a law clerk, my 2 years on law review in law school, including a year as editor-in-chief, didn't ever come up.
You tell me you don't know?
So it's an interesting question.
Yes,
and
ma'am. I know it's interesting. That's why I asked it.
Yes,
but you don't know the answer. Just tell me. I got a lot of ground to cover here.
I would be very happy to research it.
Okay. Do you know what the privileges or immunities clause is?
With respect to my answer would be the same on that.
You don't know it either.
Well, with respect to the privileges and immunities of citizenship, my recollection is that
Privileges are immunities.
yes, my recollection is that was discussed in one of the Reconstruction amendments.
Which one do you know?
I believe it was the 13th or the 14th.
Okay. All right, Judge. What's Title VI of the Civil Rights Act of '64 do? Ma'am?
Which judge?
This judge down here on the far end.
Arttow?
I can't see that
Okay.
far.
Just making sure, because there's 4 judges there. Judge Arttow, I'm going to let you answer that briefly.
Hey, I want to reclaim my time, Mr. Chairman.
You can
Madam
answer that
Chairman.
briefly.
Judge, what's Title VI of the Civil Rights Act do?
I believe that ensures that people are treated equally in any places that they would be, that they would not be discriminated against.
In all cases?
Refresh my recollection as to what you were referring to,
I'm
Senator.
referring to Title VI of the Civil Rights Act of 1964, which you're going to see every other Thursday as a federal judge.
So I believe that's under the Commerce Clause. They wanted to make sure that there was not any discrimination going on with regard to race, and that was addressing
it. It prohibits discriminating on the basis of race or color or national origin under what circumstance? Do you know the answer?
Under any circumstances where you're providing services to people?
No, it's only if you're getting federal money. You need to brush up on that one. I'm way over my time. Thank you, Madam Chair.
Thank you, Senator Kennedy. Senator.
Things started with Judge Dudik being asked a straightforward question. What is the warrant requirement? She gave a technically correct answer. Probable cause is needed for the government to obtain a warrant to search a person, place, or thing. She also acknowledged exceptions exist, like exigent circumstances and consent. Up to this point, things were fairly normal. But then Kennedy shifted the hypothetical. What if the Florida Supreme Court said, no exceptions to the warrant rule, period? Judge Dudik struggled a bit here, especially around the Supremacy Clause and adequate and independent state grounds doctrine. After some back and forth, she corrected herself. That's important to note. She recognized the error. Next up, Judge Pratt was asked if a state legislature could pass a discriminatory law. She gave an accurate but cautious answer: yes. States can treat groups differently under certain conditions, like age restrictions for driving, but not on constitutionally protected grounds like race, gender, or religion. This was an okay answer. She was clearly trying to distinguish between lawful classifications and unconstitutional discrimination. It wasn't polished, but it wasn't wrong either. Things got more tense with Judge Tay. Senator Kennedy asked about the Privileges and Immunities Clause, Article 4 of the Constitution, and the Privileges or Immunities Clause of the 14th Amendment. Judge Tay admitted that the question had never come up in her years as a judge, in private practice, or on law review. She didn't know the answer. And here's where we hit a wall. These are foundational constitutional clauses. I'll be honest, if you're about to become a federal judge, being unable to even identify where the Privileges and Immunities Clause is located, that's a red flag. Now, could she go research it? Of course. But the point of these hearings is to see if nominees are ready. This moment suggested she might not be. Finally, Senator Kennedy asked Judge Arttow to explain Title VI of the Civil Rights Act of 1964. Her answer was muddled, and she failed to note that the protections against discrimination only apply if the program or institution receives federal funding. This was another basic miss. Title VI is one of the most frequently litigated parts of the Civil Rights Act. If you're going to serve on the federal bench, you will see it. You should know it. So, what are we to make of all this? Let's be honest. Not every federal judge needs to have the Constitution memorized word for word, but these aren't esoteric legal theories. These are core concepts warrant requirements, the Supremacy Clause, basic civil rights protections. And it raises a bigger question. Are these nominees being adequately vetted before being nominated? Or are some of these names being pushed forward for ideological or political loyalty rather than demonstrated readiness? On the flip side, we also have to consider Senator Kennedy's tone. His questioning style is famously prosecutorial and sometimes borderline theatrical. His goal isn't just to get answers. It's also to make a point, often to an audience beyond the nominee, the public, the press, and fellow senators. Some may see this as just political grandstanding, and to a degree it is, but that doesn't mean it's meaningless. Exposing gaps in knowledge isn't just gotcha politics. It's part of the job. Federal judges serve lifetime appointments. They have immense power. We need to be sure they're up to the task. Here's the bottom line. If nominees can't answer basic constitutional questions, that's a problem. If they get flustered by a hypothetical, that's worth noting. But we should also have some grace. These are public, high-pressure moments. And one stumble doesn't define someone's career. Still, repeated uncertainty on core principles? That should be scrutinized. I want to hear your thoughts. Was Senator Kennedy right to press them this hard? Were these nominees unprepared or just caught off guard? Drop a comment below. And if you appreciate level-headed political analysis without the echo chamber, don't forget to like, subscribe, and turn on notifications. I break down what matters, why it matters, and what we should really be paying attention to in our democracy. Thanks for watching. I'm American Interest, and this has been another deep dive into the American political process. See you next time.